Hi folks, this is Kip from Malik and Malik, and today I'm going to be talking about a theory of causation within the realm of the Ohio workers' comp system called substantial aggravation of a pre-existing condition. And so when you get injured, you have to pursue your conditions within your workers' comp claim under three different theories. Direct causation, that's pretty obvious. You lifted a box and you felt pain in your back. Flow through, you injured your right knee, and because of the way that your gait mechanics have changed, it impacts your left knee. And then the final theory of causation in that triumvirate is the substantial aggravation of a pre-existing condition. So under 4123.01C4, generally, pre-existing conditions, you're not allowed to pursue those, or they're not compensable, except when they're shown to have been substantially aggravated by the work injury. And that substantial aggravation must be shown by objective medical evidence. And they have, when you see these motion and summary judgments drafted by employers, they'll fixate upon this. The evidence must show significant worsening, but whatever. Substantial aggravation, significant worsening. It just essentially what you'll need is if you do have an MRI or whatever, MRI or X-ray or something, and it shows that, for example, you have a disc herniation, and the disc herniation certainly pre-existed the work injury. There's degenerative changes. Then your medical provider, your medical expert will need to say, or need to look at those MRIs, CT scans, EMGs, whatever they're doing, and they'll have to say, yes, this individual has a pre-existing condition, but it was substantially aggravated, which is shown by, the findings in the MRI or the X-ray or the CT. So the reality with these substantial aggravation conditions is that folks over a certain age, once, as far as the workers' comp world is concerned, once you pass the age of 40, if you get a CT or an MRI of, like, say, your shoulders or your back or your knees, inevitably they're going to show degenerative changes. Through living in reality and gravity and the everyday wear and tear, you're just going to have degenerative changes. And in fact, they may do file reviews or IMEs, your employers of the BWC, even if you're younger than 40, and you'll see some of these independent medical evaluators interpreting, past the age of 20, they'll look at an MRI and it almost seems like they jump to the conclusion that any finding is degenerative. But in general, at the administrative level, and this is my feeling about these substantial aggravation conditions, a lot of times at the administrative level, and what I mean by the administrative level is at the level of the BWC and or the Industrial Commission. So this is before it gets to court, but at the administrative level, the consensus I kind of run into is, I think more often than not, those conditions are going to be denied administratively. And like if you have a shoulder injury, like a left or right shoulder sprain, and then you get a diagnostic, and the diagnostic shows that you have a rotator cuff tear, but there's fraying and there's degenerative issues going on there. That may be an instance where the medical examiner or the file reviewer might say, yes, this person does have a rotator cuff tear, but it's degenerative and there's no evidence that it's been substantially aggravated. And a lot of times what's required for you and or your attorney is they have to reach out to the medical provider who's diagnosing these conditions. Either that's your physician record or that's like a shoulder specialist that you've seen, and say, hey, does this person want to have the condition? Obviously they're going to say yeah. And then what medical objective evidence supports that it was substantially aggravated? And then finally, because you can't just say, oh, the MRI, finally, why does that medical evidence or MRI findings or range of motion findings and these things, why does that show that it's been substantially aggravated? And that's a lot of where we run into headwinds with particularly specialists and whatnot, because obviously a lot of these people that you're being sent to are surgeons, and what their job is to do surgery and provide treatment for folks, not draft these causal statements to rebut the BWC or employer's IME. And the other reality is, if you're going to like a surgeon who does surgery and that's all he does, the contra medical from the BWC's file reviewer or medical examiner, employer's file reviewer or medical examiner, that person may very well be a professional independent medical examiner, file reviewer, meaning like at this point in their career, that's all they do. So you could see where that's headed. If that's what your job is doing these file reviews and IMEs, you're probably going to be veering more on the side of, I'm going to give an opinion that denies this thing versus being in the middle or outright supporting it. Because if you're an IME or a file reviewer and you're saying, yeah, this person has it and it's supported, yeah, this person has it and it's supported, you're probably not going to get a lot of repeat business, and you're going to be not doing that for that long. That's my supposition. Maybe that's not the case, but when you end up subpoenaing these doctors and deposing them at these depositions and whatnot, you end up learning that some of these folks make upwards up to $500,000 a year doing file reviews and IMEs, and either for employers and the BWC or the employers and the BWC. So they have a financial stake and potentially giving an opinion that's more biased in one way than the other. Nevertheless, so getting past that, so a lot of times your medical provider, the pothole that you run into is the medical provider is not necessarily going to write the best causal rebuttal. And then the other thing is the BWC and the Industrial Commission, they look at this in that revised code section. It does say it must be substantiated by objective medical evidence, and that objective medical evidence can be per case law, can be range of motion findings, i.e., you do like if it's your knees, you can only flex and extend a certain distance. There's different little orthopedic tests, like for the shoulders, there's the Hawkins test and these sorts of things. So that's a form of objective medical evidence that can be relied upon, the orthopedic testing, the range of motion findings, the MRI, obviously that shows a CT or this thing called EMG. But one thing that's critical or crucial is that does not require to show the substantial aggravation. You don't have to have pre-injury findings. You don't have to have pre-injury diagnostics. And particularly if you're a person that has been asymptomatic and never had issues prior to this work injury, you may have very well have had a degenerative, rotator cuff or a herniated disc that was degenerative in nature. If you could very well may have that and not know that you have it because you don't feel pain, you don't have any limitations to that, and you don't notice that you had the degenerative disc or rotator cuff or knee or whatever until after you have the work injury. So, and MRIs and these things, they cost money. So if you're a perfectly healthy person otherwise, and you're in a year or two before the work injury, you're going to your regular annual primary care physician checkup, they're not going to just say, okay, we're going to order 100 million MRIs of all the different parts of your body, because those things cost money and they're expensive and you have to schedule them and all this stuff. So most people, if you're not injured, you're not going to have these things. And the courts in Ohio have recognized that pre-injury diagnostics, findings, etc., is not necessary. But, and that's true, but one thing that it also, the 4123.01C4 is at the administrative level and industrial commission level, and the employers, they're kind of focused on this notion that code section this substantial worsening thing requires a delta. And when I mean delta is, it's like a mathematical kind of idea. A change is delta. And they almost want to see a change from, you know, period A to period B. And they kind of want to see, you know, you got injured on, say, January 1st, and they want to see, what they kind of want to see, what would be perfect for them is on January 1st you had an MRI, and then on September 1st you had another MRI, and it showed like a change. And that's ultimately, if you had that, that'd be great, because that would definitely show a delta, but a lot of times it's not going to be the case. And particularly workers' comp world, most of the time you're only going to get one diagnostic, unless, you know, one MRI for the body part, unless you had like surgery and through the claim and you're still having issues, then they might do a repeat MRI. But the reality is, most of the time the BWC and the Industrial Commission are loath to authorize repeat MRIs or repeat diagnostics. So most of the time you may only have one MRI, but they read into this, the administrative and the BWC, the hearing officers and the employers and whatnot, they read into this code section as it requires to show a delta, you know, a change from A to B. But in fact, when you actually look and you look at the case law, it just says you have to have objective evidence showing that there's a substantial aggravation, significant worsening. So that could be, again, you're examined, and the case law is such that they'll have, you know, chiropractors where they show reduced range of motion. You don't have to, it doesn't say that there has to be a delta between the objective evidence. It just says there has to be objective evidence that shows substantial aggravation. So and that thought is not, that's why they're denied administratively and at the Industrial Commission, because they don't subscribe to that interpretation of it, and it's like they misinterpret, and that's my opinion of the statute. And so what ends up happening is it gets denied, the condition, and then you have to go file to court, you have to depose your expert. And at that point, the other thing that's you're going to get at a court analysis of the substantial aggravation via your expert is they're going to explain, okay, that's why this MRI or whatever shows that it's been substantially aggravated. But they'll explain it, and then you present it to the jury, and then the jury determines, do you have this condition? And so you don't need to show the delta with the objective evidence. You just need to show that that evidence supports the position that it's been substantially aggravated. And I know that's kind of nuanced, but that's the kind of nuance that that's why it's denied administratively, because they're looking for the delta. And sometimes, and they want that delta. They want the delta from, again, like January 1st to September 1st, or later. They want to see diagnostic A, diagnostic B, and that doesn't always happen. And the other time, sometimes that delta may be, they're wanting to get this, but the delta may be closer. And there's, it might actually be that it was substantially aggravated on the date of injury. The date of injury actually substantially aggravated, substantially worsened the pre-existing condition. So there's no requirement of a delta, no requirement of a change. It just needs to show that it's substantially aggravated it. And why is that significant? Well, it used to be before, Senate Bill 7 changed this code section. It used to be that you could, I guess it was a little loosey-goosey, and you just had to say, you could kind of say, rely more on subjective evidence, saying, hey, before I was asymptomatic, now it's painful, and then they examined you. To be honest with you, the way it was and the way it is now, I don't really see that it's that much different. And I almost think it's almost nearly identical. And I know that, of course, employers, attorneys would say, oh, absolutely not, it's Senate Bill 7. But if you actually look at it, I don't see that. Particularly, again, with it all, it is objective evidence. It doesn't objective evidence that shows a delta. And I know it shows a substantial aggravation, but it could be they rely upon when you read all these cases. Oh, this MRI that interpreted the one MRI that they had, it shows a degenerative changes. That is objective evidence that was relied upon by the medical expert. It was presented to the jury, and that was sufficient to find that it was substantially aggravated, pre-existing, whatever. Point being is, the trajectory is, again, that these conditions, a lot more often than not, are denied administratively, and then they get appealed to court. And I think there's also an idea that an unstated, narrative, at least, or subconsciously going through people's heads and hearing officers and file reviewers and IMEers and employers' attorneys and all these things is, you're 6 years old, you're doing whatever the task is, and you hurt your shoulder, or you're 7 years old and you hurt your shoulder, you bend over and you hurt your back. Why should the employer be responsible to pay for the wear and tear that your body has gone under? And now you're the injured worker, trying to make the employer responsible for what could have happened anywhere. And I don't know, it's an unstated kind of idea. Why should, if you're older, why should, the employers, or why should we have to pay for, again, your wear and tear and just the body breaking down? And again, I think that's another reason why a lot of times these conditions are denied administratively versus being allowed. Nevertheless, sometimes they are administratively, but again, the trend is it's going to be allowed or denied administratively. Then you're going to have to file to court, and then you're going to have to get your expert involved and have a whole court trial, jury trial, and all this thing. So that's substantial aggravation. It's one of the theories of causation to relate the condition to the work injury. Definitely, if you have a work injury and you don't have an attorney involved, and your claim's allowed for a sprain, you think everything's going great, you get an MRI and it shows degenerative changes. At that point in time, I would definitely get an attorney involved, because that's when things start getting denied, because then your surgeon or whomever is going to want to do some kind of procedure, and if it shows any kind of degenerative changes on that diagnostic, then there's definitely going to be pushback. So nevertheless, as with every one of these videos, I always recommend to everyone, talk to an attorney, talk to multiple attorneys, run your situation by them, get an idea of maybe you need an attorney, maybe they'll tell you don't necessarily need one, but definitely run your situation by an attorney. Ohio workers' comp law is very complex, it's labyrinthine, it's not necessarily something you want to do on a pro se basis. You're more likely going to run into issues if you do it on your own. So with that being said, ask your friends, your coworkers, your medical providers, relatives, hey, do you have a workers' comp attorney that you recommend? Inevitably they will. Otherwise, go to Google, search, and then as always, you could email me, you could call my office, you can leave comments. Definitely, if you want to run by your situation with us and our law firm, we'll definitely look it over, and then if we think you need representation, we'll let you know, and then otherwise we'll tell you maybe you don't need representation, and we'll give you a rundown of, hey, this is how workers' comp works, et cetera, et cetera. So with that being said, do appreciate you taking the time to listen to this video. Hopefully everything's going great in your life. Otherwise, stay safe, and thank you. Attorney Kip from Malik & Malik.